Number 83, GEICO versus Mayzenberg.
If it may please the court, Matthew Conroy, Schwartz, Conroy, and Hack, on behalf of the appellants. Your Honor, I would respectfully request 2 minutes rebuttal.
Yes.
Okay. I would like to put some temporal and historical context on this appeal. We are 52 years into the no-fault regime as we know it, and this year marks the 20th year since the Malala decision. This case, like Malala, is a certified question coming from the Second Circuit, and it marks the third case that the Court of Appeals has addressed this particular regulation. In the prior two cases, the Department of Financial Services and Carruthers and its predecessor, the Insurance Department, submitted amicus briefs in both of those matters, and the court essentially adopted the position of the department in both cases. The court should do it again here. The requirements, of course, from Peckham and New York Public Interest simply require that the administrative agency...
You're saying we should defer to DFS.
That's correct,
Their
Your Honor.
interpretation, so it has to be rational. Why is it a rational interpretation of its own regulation?
The rational portion of the opinion comes in the fact that the department, it's their expertise, and part of that expertise is balancing the interests involved in the no-fault system and in the regs themselves. They don't just deal with the provider side of no-fault, but they deal with the insurance carrier side as well. In DFS's brief, they discuss the issues related to dilatory tactics on the insurance department's part, the balancing of prompt payment, which was really, the cornerstone of no-fault being instituted in the first place.
Weren't those concerns, sorry, right in front of you, weren't those concerns also present in the prior two cases, Malala and Carruthers? And didn't they brief those as well?
They were, but the department said in both cases, we were looking to address a specific harm. And what they said in both cases is that the corporate practice of medicine had become such an issue with medical mills in New York that they essentially enacted Regulation 68 and this particular regulation to address that particular harm, and only that particular harm. When you look at the language of the regulation, it is spot on to this court's determinations in both cases. In Carruthers, you talk about the foundational licensing requirements.
But is it foundational in what sense? In the sense that they're required? Because it's not foundational only in the sense of when the incorporation is made, right?
That's true, but the foundation goes to the statute that's being violated. It's a corporate structure rule. When you look at the brief...
But you can violate that rule later after incorporation, right?
Most certainly. Most certainly. And this goes back to the original Malala decision where the words fraudulently incorporated snuck into the decision essentially because it was in the certified question itself.
So if you lose ownership or control, or you give away some portion of ownership or control later after incorporation...
Most certainly. In Carruthers,
And why can't you do that by kicking money back to a non-professional corporation?
Well, to the extent that satisfies the conditions of...
But my question, I don't know what that means. My question is, if I kick back enough money to a party that's not a professional, why isn't that the same as ceding ownership or control at a certain point?
Well, it theoretically could be, or at least it could be part of that proof, but it's not violative on its face of the business corporation law.
But isn't that sort of what happened in Carruthers? Isn't that the facts of Carruthers?
Well, Carruthers, first of all, of course, Carruthers went to trial, and the jury instructions involved some 12 or 13 factors that the jury was to consider.
So is this a fact issue then?
But the factors in Carruthers were how much control Dr. Carruthers had ceded to the non-professionals.
Well, but the
There was
control was,
financial
the
control,
control
there was
was
operational
really,
control.
it was the control of the money, essentially. It wasn't the control of the examinations. Those weren't being done by,
It was control of the operation of the practice itself. It wasn't simply taking money that.
So the violation in Carruthers, did that lead to automatic suspension of the license?
It could.
Revocation? In
It-
all cases, all the time?
Definitely not. I mean, it would require an investigation by the state licensing
Let's say they
agency.
found that that is indeed that they violated the corporate
If they-
structures
if
required
they-
by the law. Does that automatically result in,
I don't believe it's automatic. I think it's discretionary within the agency what the penalty for violating the particular rule is.
and that's also true for the misconduct alleged here?
It might be, but the violative conduct does not go to the core essence of corporate structure, and that's that.
But
I
the
mean,
core essence is control and ownership, and if it rises to the level of loss of control or ownership, why isn't it the same?
The disciplinary rules don't specifically go to any corporate issues at all. You could split.
Why can't the conduct go to those issues?
Some of the conduct might overlap in speaking to the issues of corporate control, but that's just one of 13 different factors. And DFS has spoken on this issue, and their explanation is that even though there might be some overlap, the result of it is that you're usurping the power of the agency because you risk inconsistent determinations of an arbitration panel or of a civil court or a district court.
did we do that in Carruthers?
You did not do that in Carruthers.
And why not? I
Well,
mean,
because
the agency
Carruthers-
could have disciplined Carruthers and didn't.
The department gives and takes away the tools that insurance companies have in order to verify claims. Initially, the tools that they had prior to Malala were simply looking at medical care, assignments of benefits, things of that nature, whether claims were submitted timely. After Malala, new tools were added where they could investigate corporate structure, meaning ownership, control, money, things of this nature. What's being put in front of the court today would be expanding that to include other unrelated issues. There may be overlap with money. That might speak to some of the issues,
So if they
but
had
there are
alleged.
different types of rules.
If they had alleged this in terms of money, if they had said, forget these disciplinary rules, you've kicked back enough money, so whatever it is, 10%, 15%, you now no longer have ownership or control, and therefore it's fraudulent, and therefore Malala and Carruthers apply, that would be a valid line?
I think I agree that it would. The tracing of money in these cases is always one of the seminal and core functions of proving that you have ceded excessive control to a layperson such that a carrier or a court could conclude that the paper owner isn't the true owner.
Yes, why does that even matter? Isn't the point, going back to my first question, whether or not DFS's interpretation is rational? There might be other interpretations that make some sense, but the question is their interpretation rational?
Exactly. Look, they have said we are tasked with supervising this program. And we enacted this legislation to address a very specific harm within the industry. We have done that. We have said this is what it was for, and we now have a for-profit insurance company looking to expand it. We don't want to give them that power. They are tasked with tethering insurance companies from having the ability to engage in excessive dilatory tactics.
But
in
have
the
they
claims
really, have they
administration.
really done that? I mean, there's an assertion that there have been almost no decertifications over the past decade. So is that a meaningful exercise of that power?
Well, I can't speak to how many decertifications.
Okay, but let's assume the statement is correct and that there are 13 over, however many decades with none being decertified since 2014. If that's correct, Is that a meaningful exercise of that authority in a way that actually constrains the conduct of anybody who is looking to receive reimbursement?
It is conceivable that the reason why there have not been decertifications is because the insurance companies have been engaging in self-help on this issue. There's a requirement the insurance companies...
But doesn't it perhaps raise a question about whether the regulation is rational, in fact?
I don't believe that it does.
Well, why not?
It is the position of DFS that has to be not irrational and not unreasonable. And so if their position is that we've balanced the harm in giving them tools versus ensuring prompt payment, that is the very essence of no fault. That is, to say that it's rational, it is the very job they're tasked with, balancing out what's fair.
What would you say to the argument, you said self-help, what would you say to the argument that people engage in self-help when they feel that the apparatus that's supposed to do its job is not doing it?
The system was designed to give state agencies, both the licensing board, DFS itself, powers to regulate this industry. DFS can give a private party a private right of action to enforce. They haven't done that. That's something that would have to be given to them.
And
That's
so
not-
if DFS or no other regulatory agency does anything, even when it arguably is not even contested that the conduct alleged occurred, they just get away with it, even if there is actual fraud.
The regulations put a burden on the carrier to report instances of fraud to the appropriate body. It is incumbent upon that body to do its job.
So if they report it and nothing is done, that's just it. Too bad.
I don't think the system is designed for billion-dollar for-profit entities
I
to
understand what
enforce
you're
the rules
saying,
themselves.
but the argument is, when people usually engage in self-help, it's usually that their cry for assistance fell upon deaf ears. You're saying the power exists within an entity, and it can choose to use their powers or not.
The system is designed to give certain rights in the investigation of claims and the payment of claims. My
Finish
time
your
is
answer, please, yeah.
Am I okay?
Finish your answer.
That power is specifically given or taken away. If within an insurance system, we allow an insurance company, any insurance company, to simply take rights that it wouldn't otherwise have because some administrative agency chose not to act, you're usurping the power of the agency completely. And how do you police that? How do you tether that? And I would submit that you can't.
Thank you.
Thank you.
Good afternoon, and may it please this court. Anthony Radawatso on behalf of DFS.
Counsel, can you address for starters whether the assertion in the reply brief about the incidence of decertification is accurate?
So that is an accurate number to my understanding,
Okay.
but it is misleading. And that's because when the Board of Regents, who is assigned the exclusive authority to handle matters of professional misconduct, confirms that there is a serious incident of professional misconduct, the consequence is normally license revocation or license suspension. In that case, there is no circumstance in which the healthcare provider can continue to provide healthcare services, including participate in the no-fault system. So
And is there a public source in which that sort of information is available?
how many license revocations or suspensions. So the Education Department does maintain an active list of its recently resolved enforcement matters. For 2025 alone, that list includes over 300 resolved matters.
And what about the assertions regarding the admissions here and the license and authorization here?
The license and authorization, so you referred to what happened in this case?
Yes.
So I can't comment on the existence or status of any pending investigation with respect to the professional misconduct by the providers in this case.
Is it fair to say the record does not reveal one, even if you can't comment on anything that might or might not
That's
be
correct.
pending? Okay.
Can you mentioned 300, can you just finish that?
Certainly,
Point
all I
you're
wanted,
trying to make?
certainly, all I wanted to add there is that that doesn't even include physicians, physician's assistants, or specialist assistants, which are treated separately. So it certainly is not true that the state does not police matters of professional misconduct.
But I'm sorry, I just want to be clear, what does the 300 represent?
Oh, those are resolved enforcement matters involving professional misconduct.
And is the resolution that the license is revoked or
Sorry,
suspended or
that is
annulled?
not, in many of those cases,
Yes.
there have been revocation or suspension, not all of them by any means, but
You
in
don't know
many
the
of those
percentage.
cases. Correct.
And are all of those cases that involve no-fault providers, or no?
No,
These are just, this could be for anything, could be
Correct.
a surgeon, a brain surgeon.
correct, but the point is that the state actively and vigorously enforces the professional
So
misconduct.
when the license is revoked by the commissioner, what effect does that have, or should that have, on the ability of an insurance company to refuse to pay?
When the license is revoked,
Not,
meaning.
not
oh, sorry.
prospectively, but retrospectively.
Retrospectively, it would not affect the retrospective payments. This regulation would be triggered if, in your hypothetical, where the Board of Regents has revoked a license, because in that incident, the provider can no longer lawfully provide healthcare services. They have not met
Right,
a
and
licensing
if an
requirement.
insurance company had withheld monies due to that provider for services provided, let's say, during the period when the license revocation had not yet occurred, but perhaps while it was pending, the insurance company could not, following the determination the license should be revoked, continue to withhold that money.
No, that's not correct, and I want to make this clear. So insurers have separate statutory grounds for denying reimbursements that have nothing to do with this regulation. They can always deny a claim that they view as illegitimate and fraudulent. They can also seek civil remedies against the provider for damages under common law fraud, civil RICO, unjust enrichment theories. In fact, GEICO pursued those theories in this case. They pursue those grounds for seeking damages in hundreds of cases filed in New York courts.
You know, it's a little hard to tell if it's comparing apples to oranges, right? But you said there's more than 300 matters resolved in 2025. Some of those, I presume, are license suspensions or revocations. Not all of them are. Nearly 39,000 reports in 2024. I mean, in looking at that, that's still a small slice. And again, without understanding what goes into the underlying data, it's difficult to ascertain. But why shouldn't that give us some question about whether the regulation, which you say is rational because it leaves responsibility with the Department of Ed, why shouldn't that give us some concern about that?
So there's multiple parts of your question. Just to clarify on the 39,000 reports, there were only 4,500 confirmed reports of fraud in the no-fault system in 2024. Those 39,000 is for informational purposes only.
Okay.
But it's still a lot, there's no doubt. And there is no question that fraud and abuse are persistent problems in this system. Nothing in our construction of the regulation today undermines the prophylactic function that this regulation was intended to serve, which was to root out fraudulently licensed medical providers and disqualify them from participating in the no-fault system.
Going back to my question earlier, would it fit within your definition of your regulation scope if at some point the kickbacks were of such a level as to qualify as control or ownership? Would that be possible?
Yes, I think it would. So if the facts were different than the facts here, if GEICO had moved for summary judgment on the basis that this entity was de facto controlled by these unlicensed laypersons, they could bring a claim under Malala and Carruthers and invoke this regulation and prospectively bar reimbursements on that basis. That isn't what the factual record is before this court. They did not move for summary judgment on that issue. They could do that on remand, I will add.
Is it your view that none of the definitions within 6530 would ever support a Malala-type argument by a provider?
Unless the facts, excuse me.
I'm sorry, go ahead.
I see my red light
Yeah,
is on.
please go ahead.
Unless, under the circumstances that you posited, Your Honor, where the facts alleged would indicate a cessation of control. But otherwise, professional misconduct itself independently is not a basis to invoke this
So-
regulation.
In one of the briefs is provided a list of different things, kind of a parade of horribles, and one is refusing to provide professional services to a person because of such person's race, creed, color, or national origin. So if you had a provider blatantly violating that, and GEICO or whoever came in and said, we're not going to pay you, the view of your department would be, no, you have to pay them.
No, they would not be able to invoke this regulation. The appropriate course of action in that
Is
instance
to
would
refer
be
it to investigation?
refer the matter to the state licensing authorities for
And
investigation,
in the
potentially for
meantime, I
criminal.
think as the chief judge was saying, they would have to pay this provider who's discriminating, let's say, on the basis of race, with premiums paid by people who wouldn't be able to use that provider because they were being discriminated against.
That's correct. The course of action.
Well,
again.
I thought payments were stayed. I thought during the course of some investigations, payments are held in abeyance. Did I misunderstand then the regulatory framework?
Perhaps there's some confusion, but there is a process if an insurer is verifying or investigating a claim. It does toll the period under which the insurance provider has to pay out.
So I'm clear, I think you answered this, but I'm not sure I understood the response. In the event that Judge Garcia and I believe the chief were outlining, could the insurance company then claw that money back?
If they've determined that they paid out illegitimate or fraudulent claims,
Let's assume that there is a finding by the Department of Education that there's some sort of activities that warrant license revocation. Is the insurer then permitted to claw that money back, which they have had to, as I think you said, they've had to pay out while some investigation is pending?
no, the license revocation or suspension, it acts forward-looking. However, again, if there is indication that there was some sort of fraudulent conduct or claims they shouldn't have paid out because the individual was not statutorily entitled to no-fault reimbursements, again, civil remedies are
But
available to the insurer.
if, for example, the individual or the entity was blatantly discriminating, they would have to pay that out, and they would or would not have an opportunity to recoup that if a license was subsequently revoked based
They
on...
would not, Your Honor.
I'm sorry, can you just explain the tolling point that you were making before? Because I think I've misunderstood this regulatory framework, and I just want to be crystal clear.
Yeah, no problem. When an insurer has a claim for no-fault reimbursements, it is entitled to seek verifications of the claim to make sure it's a valid claim. They're statutorily entitled to reimbursement. When they do that, the time limits to pay out that no-fault claim, which is usually 30 days, it's a very
Right.
quick turnaround, that's told while the investigation or the verifications are ongoing.
So let's stay with the hypothetical, if they make a complaint and say, there's racial discrimination, that's why I don't want to pay out to this particular provider.
Right.
They're violating whatever number of laws that are anti-discrimination laws. There's no way that they can stay that payment until that investigation is resolved?
In our view, that would not be a valid basis for the insurer to investigate the claim because they don't police matters of professional misconduct. The legislature decided it was the responsibility of the Board of Regents and the Board of Regents alone to investigate and determine the consequences of that professional misconduct.
Because they have these other paths.
Correct.
to
They have these other
Otherwise,
paths.
either get the money back or have some remedy perhaps to get could they possibly get some kind of injunctive relief?
In the scenario that we're positing.
Yes, this particular
No,
hypo.
the insurers would not have relief because, again, unless there is some sort of illegitimate or fraudulent claim where the insurer has been directly harmed.
Well, why isn't it illegitimate to its core to deny someone services based on their race?
It may be in violation of professional misconduct rules, but it is not a statutory ground for.
Why is it in violation of the human rights laws?
Oh, I do not contest that there may be
No,
other.
I understand. I'm just saying, why is, then I'm not understanding how broad the term illegitimate is
Right.
from the agency's perspective.
Certainly. So this court explained this a bit in the Presbyterian Hospital case. It derives from Section 6506 and 6506B, A and B of the no-fault law. That gives insurers it basically says that the strict time limits for payment and the penalties for non-payment only apply when a verified and valid claim is denied or overdue. That basically gives the insurers the implicit authority to not pay a claim where the statutory criteria for eligibility are not met.
Thank you.
Thank you.
Thank you.
Good afternoon. May it please the court, Barry Levy from Rifkin Radler for the respondent, Government Employees Insurance Company. I'd like to start by just discussing the context in which this case comes to this court. This case doesn't come as a result of some verification process. This doesn't come as a result of some investigatory conduct on the part of Department of Education or DFS. It comes to this court as a result of summary judgment based on a full evidentiary record in which the facts in this case were not only affirmed by the district court, but by the Second Circuit as well.
Counsel, did you ever argue in that proceeding that this type of conduct could rise to the level of loss of control or ownership?
We did, Your Honor. If you look at the Second Circuit's opinion as it relates to the way that it characterized the oral argument, and this was in the briefs in the Second Circuit, we argue it as a matter of public policy that, as you said, that the kickbacks have the same effect that the corporate practice of medicine do. They involve the same elements, which fundamentally come down to control. And whether you label it as a corporate practice of medicine violation or you label it as a licensing violation.
The DFS takes a position that you can proceed on that claim. Is this in dispute? Do they say you are now barred from raising this claim?
Well, I don't think that they're saying that we're barred. What they're trying to do is they're trying to repackage or label the way that this was argued to try to preserve some artificial distinction in the regulation between the corporate practice of medicine and the payment of kickbacks. When you look at them and you look at the left hand and the right hand, there's absolutely no fundamental difference.
So what is the rule that you would like created, and how would it work in practice?
I think the rule is what we articulated in our brief, is that we believe that the Malala and Carruthers overlay on the conduct as it relates to these types of behaviors is the way that you measure these elements. So in other words, conduct on the part of the licensed professional that's willful, that's material, and that's grave, okay, in essence that it has...
How do you determine, who makes that determination?
Well, ultimately, in the context of reimbursement, right, and it's important to distinguish between what happens in the licensing capacity or in the regulatory capacity in terms of what happens as far as reimbursement is concerned. So ultimately, the insurance company would look at the facts, would decide whether or not to pay, and based upon that determination, it ultimately would go to court.
So is that usurping the regulatory agency's
Not at all,
job?
because the regulator and the insurance industry work on absolutely parallel paths. They never intersect. And the fact of the matter is if you look at the original Carruthers decision, which was the last case that came before this court, there was absolutely no intersection. And in fact...
You're making an intersection when you decide that you're not going to pay, and you're not allowing them to do their investigation and come up with their discretionary result.
But to the point that the DFS made, if I decide not to pay and I defer to them in terms of their investigation, and ultimately, several years later, however it is, they conclude that there was a misconduct and there was a licensing violation, the remedies that they can impose are only prospective. They can only deal with the question of what's the impact on the professional as far as the license on a going forward basis.
What situation would we be in if they came to the conclusion years later that there wasn't a licensing or other corporate misfeasance?
Wouldn't be in any particular situation, Your Honor, because...
Well, what happens to all those payments that hadn't been made?
Well, if you're in the context of a court proceeding that's already ongoing, a judge, a jury, a court of appeals would decide on whether the facts do or don't.
But isn't that part of his point, that you would then be circumventing the legislature's decision and framework of how one would challenge any determination from the Board of Regents as to whether or not there has been professional misconduct? You only get to do that in Article 78 with limited review.
But
You're
that's
looking for
only,
plenary review.
but that plenary review is left only as it relates to the license of the professional. If you look at ultimately what the remedies are under the education law,
Yeah, but under your rule, it means you could raise any professional misconduct, even one that appears so peripheral that it would unlikely lead to revocation of the license.
no, I don't believe that's what we're advocating, Your Honor, and I don't think that's what
Well,
we're
how could it
stating.
not? Isn't your position that this includes rules and standards of professional conduct?
Well, if I go
It means
back,
all of them.
if I go back to the same analogy that was raised in Malala, right? What was raised in Malala was this whole notion that we were going to raise technical violations of the business corporation law. And-
But you are suggesting, I take it, that your definition of willing, material, and grave goes beyond something that effectively allows for financial control of the corporation, yes?
Well, I think, yes, Your Honor. but
Okay,
I do-
and so if that's correct, won't there be some number of cases? Let's assume that you would say peripheral violations won't count because they don't meet the material and grave standard. But won't there still be some significant number of cases where there will be a reasonable dispute about whether or not that should mean that payment is not required, and then that payment will be delayed for years during the course of an adjudication, which seems to me in tension with one of the primary goals of the regime?
Well, but the question is, what is the goal of the regime in this context, right? So if the goal of the regime in this context is for insurance companies to be in a position to not have to pay claims, right, based on healthcare providers who are engaged in what's clearly unlawful and
The
offensive
clearly
behavior.
unlawful, I guess, I think is the question, right? It seems to me the DFS is telling us that the goal is to err on the side of timely payment and that there will be disputes about what rises to the level you just articulated. And in those circumstances, what should happen is that payment is made because that's the primary goal that the legislature had in mind. So why isn't that right?
Because under those circumstances, based on the way that DFS operates and the Department of Education operates, by the time that they come to a conclusion, their determination, one, is only prospective. Number two is not necessarily binding as far as the insurance company has gone. And from a practical sense, the money is gone.
But we were talking about legislative policy priorities, and I think Judge Halligan is correct that the stated clear legislative priority is prompt payment of claims, not, protections for when insurers believe that the claims are improper. There's a different mechanism provided for that. It doesn't seem to really protect you in the context of making those prompt payments, but it does provide a remedy in due course.
But the remedy it provides, Your Honor, doesn't have any impact as far as giving us the ability to either claw the money back or for the purposes of denying the claims. Because let's just take this particular case for example. Here we are in 2025, okay? We're talking about a healthcare provider who engaged in behavior between 2015 and 2017 that was put into the public domain in 2018. The claims have already been paid, what's been paid. There's already a dispute. Absent the litigation that GEICO brought, we would have already paid the money out. The money's gone.
But where's the legislative pronouncement that that interest is superior to the interest in making sure that claims get paid promptly because we assume many of them are completely legitimate?
Because the overlay of the department's, in other words, what the department is doing is it's drawing an artificial distinction here in contrast to what it did in Malala. In Malala, we're talking about corporate licensing. Here we're talking about professional licensing. The underlying rationale in Malala was that the insurance companies should have the ability to look behind the license, the facially valid license, to deal with that. The only difference here is we're talking about a professional license.
But I think DFS, I took DFS to be telling us that is a distinction that they're drawing and that that's reasonable in part because there are many requirements that the licensed entity has to comply with. Some of those may be violations of some may be more serious than others. And so rather than create a window for drawing lines and disputing, that it would proceed as you essentially said that it would, that you would be required to pay out even if you had an argument that perhaps you shouldn't.
But if you go back and you look at the text of the regulation, which is where I think you have to start,
Yes.
if that distinction truly existed, the word any licensing requirement wouldn't exist in the regulation.
Okay, but DFS does argue that that is the way it would have us read the regulation, and I think our cases say that we owe some deference to that reading.
Unless the literal language contradicts what that reading is. And when you read the language in this case, what DFS is saying is that the word any, we're going to read that out, or what we're going to do is we're going to replace that with the word corporate. And that's not what the regulation says. And if the court goes back and it looks at its decision in the visiting nurse services case, it dealt with this very issue, which is that the language that the regulator in that particular case had written was inconsistent with a later interpretation that it came up with. And the interpretation here under A12 and its corollary to the disciplinary rules has been in the public domain for the better part of 10 years. DFS has never weighed in for the better part of 10 years since the case was decided in the district court called State Farm versus Badia, which is the first case that took this position. So here we are dealing with really what we feel is a completely different or a change in position. And the DFS does this in a number of regards, not only with respect to the text of the regulation.
Why aren't the other remedies that DFS has identified, and you've got other claims that would give you remedies, why isn't that sufficient to protect GEICO?
For two reasons. Number one, a lot of the remedies that GEICO has fall within or outside of this 30-day rule. In other words, this 30-day rule was enacted by virtue of trying to prompt payment. And what healthcare providers say is, well, hold on a second. If you're going to sit here and you're going to take the position that I committed fraud, then you should have discovered that fraud within the 30 days. So the eligibility issue, the question of whether under A12 a healthcare provider is or is not entitled to payment, falls outside of that 30-day window. And so therefore, the insurance companies aren't restrained by some artificial extension of what exists in the no-fault system when it goes to either seek declaratory relief or file for a clawback. And that in Malala, the cases have since decided that this is an eligibility issue and the 30-day rule doesn't apply because the DFS modified the regulation, I believe it was in 2008, to say that eligibility issues aren't borne out by that 30-day rule. But from a public policy standpoint, if we look at the behavior here and we look at the offensive nature of what took place, why should we be relegated to those supplemental remedies? Why shouldn't the court say, as a matter of policy, we're not going to condone this type of behavior?
Counsel, if the insurer prevails here, under the scheme here, the provider takes the loss, right? Not the patient. The patient doesn't have to pay, right?
Well, the patient assigns its benefits, Your Honor,
Right.
at the time of service. So the patient is never on the hook for the money.
So the effect of a ruling in favor of the insurer in these types of cases is the provider takes the loss.
The provider takes the loss because the provider took the risk in engaging in the behavior at the time that it was treating the patients. And that's true as far as fraud and abuse is concerned in every payer system.
That's one of the things, or it gets to one of the things that I find a little difficult to think about in this case, which is in Malala and Carruthers, I think we both say that there's a strong prohibition policy against professionals splitting their fees with non-professionals. That's sort of the underlying principle that's being vindicated for good policy and public policy reasons, I think. And in Malala, we say it doesn't actually matter that the services that were provided were all necessary services and were provided competently and so on. That doesn't actually affect what we think about this fee-splitting prohibition. And here we have, I think, something that looks like fee-splitting and I think, proof that some of these services were actually unnecessary. So it seems a little hard to understand how to reconcile this with Malala.
Well, I think if you look at it I don't think you reconcile it with Malala. I think these cases line up absolutely the same. I think if you look at all of the public policy issues and all of the factual issues, Malala Carruthers and this case line up identical. The only difference is the label we're going to put on it. Are we going to label this as being a professional misconduct violation because the kickbacks were paid in violation of subsection 18 of the insurance law, or is it fundamentally just conduct?
I guess what I was trying to get at is here there may actually be harm to the insurer because some of these services were unnecessary, whereas in Malala we assumed that they were all necessary services.
That would be true, Your Honor. This case, and to that point, this case lines up with Carruthers the same way, because in Carruthers, what we were talking about were MRI services that were rendered to patients that were dangerous, that were medically unnecessary, that gave false results. And the record of this case
But
proves...
why isn't that your fraud claim, that DFS doesn't dispute that you can proceed with?
Because that's one element of it, Your Honor, and that shouldn't be the only element
Why
or
shouldn't
the
it? Why
only basis.
is it that rational? That you've got other claims that you could proceed on, but if you want to challenge payment and the eligibility for reimbursement of a provider based on any professional standard, that you can't proceed on because that's left to them specifically.
Because what Mr. Conroy will argue, if this case is remanded on that basis, is that GEICO is precluded or foreclosed by virtue of the 30-day rule and other artificial rules that exist in the no-fault system from pursuing its declaratory judgment action.
I don't even understand that.
Okay,
I don't know what you're talking about.
So because of the 30-day rule, which is the prompt payment rule that exists in the no-fault regulation.
Yes,
what
unless you raise that there's fraud.
No.
That's the way it
But-
works.
but
If I
fraud-
misunderstood that, please correct me.
But fraud in the sense
Yes.
of treatment fraud or billing fraud is not necessarily outside the rule, the 30-day rule, Your Honor.
What case says that?
The-
Or what reg or statute says that?
The DFS it's been I can't think of the case off the top of my head, but that's been the rule in New York for the better part of 25 years, going back to, and so as far as...
Let's say that's not correct. Let's say that is not the rule. Does that in any way undermine your argument?
Because then what we're doing
Let's
is...
assume that the 30-day is not a bar in the way you're articulating it.
But we're rewarding providers. We're saying to
Well, you'd be
providers...
rewarded. You would have an action to try and prevent payment, to try and have the court agree with you that they're not eligible for reimbursement.
But if a healthcare, under Malala,
Yes.
if a healthcare provider or under Carruthers, if a healthcare provider is not eligible for payment,
Right.
okay, because they have engaged in the corporate practice of medicine, in which, to your point, Judge Garcia, and yours, Judge Wilson, essentially they've abdicated control. When you look at the record in this case and the magnitude of the kickbacks that were given, right, and the fact that, as the Second Circuit said, no payment, no patients. This is just another form of marionetting, all right? Why should the burden on the insurance
No, but
company be greater?
But the DFS's position is you can still make this argument. You can say that it is essentially having given up ownership and control.
And I don't disagree that necessarily our positions, Your Honor, that the daylight between our positions are materially different, okay? I really don't disagree that the daylight isn't that much different. I just think that it's too restrictive of an approach because it ends up imputing into
That's not the question. The question is whether or not their interpretation is rational.
No, I
Why is
don't-
it irrational? Or why is it not rational?
A couple of things. Number one is that if you look at the text, their interpretation of the text is not consistent with the text. They argued, which they appear to be
Well, it
backing
says
off.
licensing. It doesn't say professional codes of conduct.
No, it says licensing.
Right.
But in order to...
You agree licensing is obviously broader.
Licensing has a much broader context than that and should
minimum.
include the conduct which is necessary.
Do you also agree that there are parts of the education law that refer to standards of conduct separately from licensing requirements?
I don't know that there are parts of the education law, there are parts of the education law, the way that it is written, that talk about what is or is not misconduct. But whether it would be necessarily a licensing.
You have a section of the education law that refers to a licensing requirement and then cites a standard of conduct.
No, I don't believe that's the way the education law is written. But I do think that when you look at what the education law says, you have to abide by these standards in order to maintain your license. And one of the distinctions
Is
that...
it to maintain your license or just to obtain your license?
No, both to obtain and maintain your license.
Where is that authority?
If you look at the application process for physicians, and you look at the application process for other licensed medical professionals, they have to recertify every number of years.
So then wouldn't the regulations say provider and licensee?
No, because the provider is by definition the licensee, because you can't be a provider in New York without having a professional license. They're one and the same, Your Honor. But to the point I was making, I'm sorry, Your Honor.
Your time is up, but
Oh, I'm sorry.
wrap up if you can.
Yeah. The point I was making is that one of the distinctions that they make, that the DFS makes, is that, well, a professional corporation has to recertify its existence every so often. And so therefore, in some way, shape, or form, that's like a reaffirmation or reattestation. Well, so do licensed physicians. And in doing so, if you look at the application process for recertification, it talks about having engaged in disciplinary conduct that violates the disciplinary rule. It's no different. That's why I say these cases line up perfectly, except for one very simple fact, which is that they bring the issue of professional license into the equation in the discussion. Other than that, there is no distinction between this court's rulings in Malala and Carruthers and this particular case.
Thank you.
Thank you very much, Your Honors.
I have two brief points. This case and Carruthers do not line up at all. Carruthers very specifically talks about foundational core licensing issues. I would point out that the question of whether DFS has changed its position is exactly the same. It makes reference to its position in both Malala and Carruthers. The court, on the strength of the regulation, which in its amicus brief, DFS said, we did this to combat the corporate practice of medicine in the form of medical mills. With Carruthers, they write in their amicus brief, the purpose here was for core, and they use the word core, licensing violations. The court took the word core and turned it into foundational. There's no view of the simple language of disciplinary rules to call that a foundational corporate requirement. Secondly, and I'll be brief, to suggest that there's no distinction or it's an artificial distinction between kickbacks and the corporate practice of medicine is simply not true. DFS lays out what it seeks to prohibit by the corporate practice of medicine, and that is constraints upon professional judgment, invading professional integrity, and permitting business corporations to make professional decisions. In this case, what you see is the professional paying money to essentially a marketer to generate work for the practice. No involvement in the practice, no involvement in medical decision-making, and
But you could have an
juxtapose
owner,
that
you
with-
could have
with-
an
with-
owner that's not involved in any of that. They're just taking a stream of income. And under your view, that would be okay? That wouldn't violate their precepts on that
it's just a
practice?
different issue, that's all. With Carruthers, you had the lay people, who would be the equivalent of the Dovmans in this case, they operated the office.
Yeah, but what if they didn't and they were just receiving money, but they were owners? It
But
would
they had
still be a
nothing- they had-
violation,
they had-
right?
They had otherwise, well, the passage of money would have to be so pervasive that they would deem to be the true owners of the
So if
PC.
there was a 25% ownership stake, then under Carruthers, that wouldn't be enough.
But it may or may not. That might be a jury. That might be a question of fact. But this goes to eligibility based on foundational structural laws. It
Even
goes
if
to the
they
BCL issue.
incorporated with a silent 25% partner who is receiving 25% of the profits, and that's undisputed, that would be a jury issue under Carruthers?
Yes. There would have to be
What would the
sta-
jury,
I mean,
why
there-
wouldn't
there-
that be a question of law? What would the jury be deciding?
It might be a question of law in favor of the provider. I mean, there are probably 12 or 13 factors enumerated by Carruthers, and if the only one was the passage of money, I'm not sure that's going to cut muster, but the money
You don't
portion still
disagree,
goes to
you don't
control.
you don't disagree that if for some reason the answer to the certified question allows them to proceed, that they can make this argument that the payments here essentially were turning over ownership and control of the practice.
The factual argument
Yeah.
that the lay owners are financially benefiting from the practice is part and parcel of every Malala-based defense and RICO case. The money is always
But
part
is that
of
a yes or a no?
But it's not based on a violation of the disciplinary rule. It's based on
Okay,
the
no, I know
issues
that.
enumerated
That was
in
not my
Carruthers.
question. My question is, do you disagree, because I thought that was DFS's position, do you disagree that they could make this, if indeed we answer the certified question in a way that they eventually are able to return to district court?
In this case,
Yes, in this case.
I think they would
Can
have
they
to
make
move-
this argument?
I think they would have to move to amend the complaint to change the theory of eligibility. That it would be based on Carruthers and Malala, not based on a violation.
You think they didn't make this argument?
They did not make this argument.
Thank you.
Thank you.